Beth. Recording in progress. Great. So let's just get started.
Thanks, Christoph. I'm going to share. Yeah, it's the first time I'm presenting, but I think that when you co-convene, you cannot be the one presenting all the time. The whole point is to showcase others as much as possible. But having said that, I am really, really happy to be presenting this time. Um, So can you see the
Yes,
slides?
we can.
Okay, good, good. Okay, so this is partly based on a chapter which is forthcoming in the Cambridge book on human rights for the mind, which has been co-edited by Emma Dorhorgan, Schloss Lighthout, Gerben Maynor, and Philip Kalminer. Um, so big thanks to those editors because it gave me an opportunity to explore some of the questions that are raised today that have been niggling away at me for a few years. But I really narrowed down the focus in this chapter to a very specific, partly hypothetical, but perhaps not completely hypothetical case study, which is the use of neurotechnology in a coercive and interrogational setting against someone who is in detention, whether that is um, law enforcement or whether that is in some kind of military detention, where we know we have lots of different techniques of interrogation and questioning. So the fact that then some of these questions were raised more recently in the Council of Europe report just really made some of the things I'm grappling with more pertinent and potentially more urgent. So if you look at the slides, all of these images were made by humans. I can confirm. So we have at the top the first one, an etching of a torture chamber from the Spanish Inquisition era. And you can see this kind of imagery is still quite pronounced in the kind of collective imagination of what torture amounts to. And then next to it, we've got uh, depictions of torture by a still tortured person. So this is images by Abu Zubaydah, who is still detained in Guantanamo Bay over 2 decades later. And he released a whole host of drawings which depict various different torture techniques. Then we have a photograph, which of course by now is hugely infamous. It's the hooded man from Abu Ghraib, which was the US ran base in Iraq. But of course, we knew and subsequently found out that other coalition forces, notably the UK, were engaged with what those states, particularly the US, retermed as enhanced interrogation techniques. And then I found this image, the final image online. It's an image created by a kind of animator called Chen Liang. And just as a depiction of what a mind reading machine could look like in a coercive interrogational context. You've got the kind of head scanner, you've got the handcuffs, you've got various different apparatus. And I suppose these images can capture the evolving nature of torture, but with a question mark over the final image and whether that would amount to torture or not. And of course, that's what we're going to be discussing. And I just want to clarify at the outset that the neurotechnology referred to in this case study is brain imaging, including neuroimaging, used to detect the recognition of stimuli presented to the person in the machine to reveal information known by the suspect, or to um, reveal whether or not they are trying to deceive the questioner or interrogator. So I'm interested in the overlap between freedom of thought and the prohibition on torture and cruel, inhumane, degrading treatment and punishment for lots of different reasons. But narrowing it down to this case study of pain-free but coercive interrogational use puts pressure on the definition and application of the prohibition. And it also demands a clearer understanding of what the interests at play are for freedom of thought, particularly if practice like this would fall within the absolute remit of freedom of thought. Although some scholars, like Schlors Hart, who unfortunately isn't here today to defend himself, argues that this type of scenario should fall outside the absolute protective remit of freedom of thought. And I just want to clarify that this wouldn't be in a kind of pre-crime sense. So, it's not, this technology isn't being used against someone who has not yet been charged with an offence. And the justification from Shaw's and perhaps others for this scenario not falling within the protective remit of the absolute and unconditional protection freedom of thought provides is that it can be counted against other demands. So extracting accurate information can help prevent the imminent loss of life or limb, and that the individual is someone that the officials are almost certain, as far as they can be certain, that individual possesses that information. So just returning to those images, so we can see that from the first two images that torture has always previously been associated primarily with pain. So the infliction of the pain is for the purpose of extracting information or a confession or to punish. At some point, torture techniques became informed by modern science, and from here sprang the enhanced interrogation techniques. But we see the introduction of technology, obviously electricity, like in the Abu Ghraib image. So if we isolate the use of this neurotechnology in this context away from any kind of physical brutality that might accompany it, we're left with the question of, well, would it amount to torture or not? And if not, why not? Does the absence of pain automatically release it from the severity threshold of torture? Although it may still amount to cruel, inhumane, degrading treatment or punishment, even though such treatment is also prohibited. And then the next question is it a violation of freedom of thought? And if so, why? And this is where we can use this case study to elaborate the elements. And of course, it can be a violation of both rights at the same time. And I think these are interesting questions, because one of the arguments for introducing more and more technology into interrogation scenarios is that it would help eliminate torture, that interrogators and the police, they wouldn't have to reduce the questioning to physical brutality or mental, psychological torture. And so if we adjust the practice of torture according to the technology, does it demand a refreshed view of the definition and threshold standard? And we will see in a minute that that has occurred over time. Another question is, if such technology was accurate and could be relied on outside of a clinical controlled setting, would the state have a positive obligation to use such technology to protect the public? And also, if the technology did become reliable, would this do away with one of the arguments against torture, which is its inability to yield reliable intelligence? And I think to answer some of these questions, we can take a closer examination of certain elements that are present in both rights, arguably, which are coercion, powerlessness, and a lack of control. Um, and obviously, it should go without saying that any use of neurotechnology or any of the technology that aids this type of intelligence gathering can only ever be considered lawful in the context of a legal system that protects all due process rights, access to court, right to legal representation, avoidance of arbitrariness, especially when it comes to the deprivation of liberty, and where there's a police force, military force, intelligence agency subject to accountability. Let's just turn to this slide. So we know that freedom of thought is contained in various different international treaties, but that the areas of protection, although not explicitly set out in any treaty, have been established under case law, particularly the European Convention on Human Rights, which has a significant volume of case law regarding Article 9, which protects thought, conscience, and religion. And we know that these areas of protection at least include no one can be forced to reveal their thoughts. Question could be, can the police ever compel suspects to undertake such brain reading tests to extract accurate information to save a life or prevent loss of life or limb? Number two, no one can be punished for their thoughts alone. So can the state or another person ever punish someone else based solely on unmanifested thoughts? And finally, no one can have their thoughts impermissibly altered. So coercive education, re-education camps, or coercive conversion therapy could apply, but I'm not going to focus on that for the rest of the talk. It's not directly applicable. Just turning to the prohibition against torture and cruel, inhumane, degrading treatment and punishment, a universally accepted definition is elusive, and there are various international human rights treaties that formulate the prohibition slightly differently. And so the case law has developed various iterations of the prohibition. Another point is that although there's no hierarchy of rights, and all forms of ill treatment are absolutely prohibited, as I said earlier, the law does distinguish between torture and other forms of ill treatment by attaching a higher level of severity to torture, and that there has to be an impermissible purpose, for example, to force a confession, and also there are other varying contextual factors, including where the ill treatment occurred, who, by a state agent or with the kind of consent or instruction of a state official. We have to also consider the level of control the perpetrator has over the victim as well in determining whether treatment falls under torture or other forms of ill treatment. And this classification of treatment is because there are legal obligations attached to the prohibition of torture that don't arise in relation to other forms of ill treatment. So it's formulated, mostly no one shall be subjected to torture or cruel, inhumane, degrading treatment or punishment. The ICCPR adds in no one shall be subjected without his free consent to medical or scientific experimentation. Article 1 of the UN Convention Against Torture is quite broad because it includes any act, mental or physical, that induces severe pain or suffering for the purpose of obtaining from a first or a third person information, confession, and to punish them, to intimidate, to coerce for any discriminatory purpose. And UNCAP specifically highlights powerlessness, and that's something I will turn to again later. Under Article 2 of the Inter-American Convention to Prevent and Punish Torture, it's quite unique in that it states torture shall be understood to be the use of methods upon a person intended to obliterate the personality of the victim or to diminish his physical or mental capacities. Now, this idea of obliterating the personality or the will is something that does feature in case law, for example, including under the European Convention on Human Rights. And the centrality of treatment that undermines or breaks the will of the person is something that really helps us understand the extent to which coercive, pain-free interrogational use of neurotechnology would or would not amount to torture. Because, of course, focusing on the centrality of pain and mental suffering would mean that neurotechnology in this context would fall outside the scope of torture. But if we consider more contemporary iterations of the emphasis upon the critical components of the treatment, which are not the severity of the pain and suffering, but more so the purpose of the conduct, the powerlessness of the victim, and that the purpose is to break the will of the individual or break the physical and moral resistance, to destroy dissent or resistance of some form, to make them confess, to drive them into submission, or to drive a person to act against their will unconscious. This is all terminology used by various different courts or treaty bodies. Then we see that actually torture arguably would apply. And an academic, Natasha Mavronakola, has taken this further by redirecting the aggravated wrongfulness of torture as being orientated around the relational aspects of the conduct. Again, so that notion of breaking the will of the individual. But so there are areas of overlap when we're looking at these two rights. They both clearly protect or offer protection for forum internum. The term forum internum isn't used in any of the case law related to torture, but if we understand it as persons in a realm when mental faculties are developed, exercised, and defined, and if we consider both rights to one extent or another as protecting the mental integrity of the individual and their mental capacity, and think about the extent to which courts consider the lasting effect of torture upon the mind of the victim, then we can see that there is that overlap in terms of the protective sphere. And of course, there are the normative underpinnings which are shared: dignity, autonomy, integrity, self-determination. So in a practical sense, in a way in which we can have a coherent framework, how can we consider the way freedom of thought, the prohibition of torture to work together? And this is where I'm going to refer now to the Council of Europe report. One proposal is that these two rights are read in conjunction. I did say earlier that it's possible for there to be a violation of both rights simultaneously, but at least one commentator, Vasilis Zeopoulos, Zevik, who is the drafting rapporteur for the UN Human Rights Council Advisory Committee, who are currently working on guidelines on neurotechnology and human rights, spoke at a Council of Europe event on human rights and technology, and the report was published quite recently. And in that report, it's recorded that there could be one proposal, which is that there would be a division of labour between the two rights. So they ought to be read in conjunction. Where Article 9, at least on my reading of what was reported, would release its absolute status so that it becomes subject to a balancing exercise. And under this kind of moderated view of Article 9, it would protect still a reasonably wide range of mental interferences, including manipulation of mental processes, undue influence, and interference with cognitive autonomy, but again, subject to permissible limitations and then a balancing exercise. And conversely, Article 3 would be the right providing the absolute protection from the most serious violations of mental integrity involving coercive brain stimulation and relevant for the case study explored here, forced thought extraction. That's how it's termed in the report. So that's one proposal. Of course, when there are two rights at play, it is possible for the court to determine one right or one body of law to become lex specialis. But that doesn't seem to be something that was kind of explicitly proposed. The proposal is that somehow Article 9 sacrifices its absolute remit, and Article 3 steps in. So just responding to that, it is common for rights to overlap. And I suppose my initial points of concern are that, firstly, there must be an alternative practical way of protecting and upholding rights in the context of detention, a detained person being coercively forced to subject themselves to neurotechnology to extract information or confession or whatever. So there must be a way to apply those protections without sacrificing the absolute status wholesale. And it would be quite an unusual approach to take to find a coherent test for applying two overlapping rights where one characteristic of the right is completely forsaken. So there must be another way to apply these two rights together without diluting the protective remit of Article 9, because ultimately the absolute and unconditional component is not under doubt. I mean, it's been reiterated time and time again. The question is the extent of its scope, which is a different question from the one being proposed here. And if we think of forced thought extraction, it would seem to fall squarely within the remit of freedom of thought, just like other forms of impermissible interference or punishment of thoughts alone fall squarely within its remit. So in proposing this division of labour, Article 3 would be doing all the heavy lifting that Article 9 arguably should be doing. Um, so there's an argument to say that Article 9 is the most applicable right in this context. And that's not to say that the prohibition on torture should not or does not explicitly protect the mind, and in fact, a clearer recognition of the often irreparable, profound, and long lasting harm torture and all other forms of ill treatment inflict upon the mind of a victim would give fuller recognition and reparation to victims. But I don't think we have to sacrifice one in order to achieve the other. But I think what we can concede is that for freedom of thought to apply in this context, there needs to be a much more developed conceptually and doctrinally understanding of freedom of thought in order for it to accommodate a case like this, especially if states do desire, which I think we could assume they would, desire to use such technology. So I mentioned earlier elements of powerlessness, lack of control, and coercion. I think the development of those can help us bolster up the way in which freedom of thought would apply in this context, its justification for applying in this context, and potentially the scope of freedom of thought more broadly. Powerlessness, as mentioned a little bit already, lack of control, I think, is quite evident in this context where someone is deprived of their liberty. Coercion is not as clear. So I'm just going to spend the remainder, the last few minutes, just fleshing out some questions around coercion, as far as it is one of the underpinning elements for freedom of thought. So the Human Rights Committee considers coercion to include actual or threats of violence, penal sanctions, as well as restrictions on access to education, medical care, employment, participation in public life. That doesn't appear to be directly applicable here. But coercion has also been considered to violate the victim's inherent dignity and their right to freedom of thought, conscience, and religion. And of course, Article 18.2 of the ICCPR establishes as an unconditional norm freedom from coercion. And some forms of coercion in themselves may amount as well to torture or ill treatment. And in that context, we can include confessions. And so the freedom from coercion to reveal thoughts or beliefs, although that's not the terminology used in the case law or in Article 18.2, freedom from coercion to reveal thoughts would be a logical extension. But returning to the case study that we're looking at here, is it coercion in the same sense when you're coercing someone to submit themselves to the neurotechnological process or procedure? So the coercion in that context is not necessarily directed to changing the content of the thoughts, which is a lot of the Article 18.2 ICCPR case law. It's a different type of coercion. It's coercion that is used to reveal the information or knowledge upon which to base punishment or further treatment or a loss of liberty or something else. So it seems to me that this is the element of coercion is something that needs to be very much developed before we can have a very coherent or more coherent developed account of why this case study would fall under the protective remit of freedom of thought. Just to conclude, it does appear to me that given the right to freedom of thought does squarely protect inner thoughts, which I think would include knowledge or information, it would be inconsistent for the right to not also prohibit the use of neurotechnology to extract information against the person's will in circumstances of a loss of liberty. Um, because again, those normative elements of autonomy are at play. And of course, the context that someone has limited power to resist the intrusion and the implicitly high degree of control that someone is subject to in that context. So, to conclude, I think there are still lots of questions. It's a very interesting topic, and yeah, welcome any thoughts. Thank you very much for listening.
Yes.